Conservatorship letters. Hi, I'm Darren Findling of the Probate Pro, and I'm going to explain the process of obtaining a letter of conservatorship to allow you to handle the financial affairs of an individual upon which is in need of court protection. This SCAO form, S-C-A-O, form 645, PC 645, can be readily found through Google or any of the court's websites, or if you contact my office, we're happy to hand it to you. This letter of conservatorship is the document you receive from the court when you are appointed conservator of an individual. That process begins with the petition and ends with the appointment through an order and the issuance by the probate court of a letter of conservatorship. And this is the document you receive. It'll have a nice little seal or emblem on it to show that the document is a certified document from the court and gives you the authority to act financially on behalf of that individual as the conservator. This is a type of fiduciary responsibility. Now, with all of the SCAO forms, and this one is no different, the form itself tells you the relevant statutes and court rules that govern the form. And as you can see, MCL 700.45 5412 and other statutes and court rules that are listed here can give you the full breadth of information to understand how a conservatorship works. But we strongly urge you not to do this on your own, to hire a good, skilled, competent probate practitioner to assist you through this conservatorship process, because most of the responsibilities, many of them may be intuitive, but some will not. And you can get yourself into a whole heap of trouble if you fail to timely do your responsibilities, or in some way if you breach your responsibilities as conservator. Let's make our way through the letters of conservatorship. At the top, you'll see that there's a place for the county court, and as well as the case number and the estate name, or in the matter of, and that is the individual that's under protection. That's the estate name at the top. Then it identifies in the name and address section the name and address of the conservator, or if there are co-conservators, the two people's relevant contact information. It also identifies in the checkbox whether the person is a limited conservator or a conservator of the estate. Now, what that term means, limited, is that there are times that the conservator may not have full authority over the individual's affairs. Their powers may be limited to a particular issue. It may be a particular issue relating to an asset itself, or certain rights and duties that you have on behalf of the totality of those powers. So it's important to look at any limitations or restrictions that are on that letter of conservatorship to see if the conservator's powers are in any way restricted, or if some of those powers are somehow first, there's a condition precedent that you get court authority before your powers are affected. So those conservatorship letters may have limitations and restrictions, and it's really important that you read those. Now, typically, those powers are broad, and they're defined under EPIC, the Estates and Protected Individual Code, that gives the powers on behalf of the conservator to act. The next area is the judge's signature, as well as a date, as well as the deputy registrar's signature. And this gets a little confusing, because although the letters of conservatorship may be issued on a particular date, they may get updated by the court to show that they are still current. So it's really important to look to make sure that there's no expiration on those letters of conservatorship, and that you're looking at a document that is still effective from the court. So often, institutions like banking or financial institutions will require a recently dated or certified letter of conservatorship to be assured that they are dealing with a document that is still current and valid through the court. We're going to now take a look a little deeper into this document on the flip side of the document that reflects some of the notices and responsibilities of the conservatorship. In this particular case, these are delineated here only to give you a few of the responsibilities of conservator. In no way should you think that by reading the backside of your letters of conservatorship that somehow explains the full responsibilities that you as the conservator have. It's really important that you understand all of the duties and responsibilities, because again, failure to do so can get you into a whole heap of trouble, which can include removal, sanction, surcharge, as well as criminality for any events that are in violation of the Michigan Criminal Acts. So it's really important that you follow and are guided with a good, skilled, competent probate practitioner. One of the key requirements occurs early on, and that is to file an inventory of the assets that you're in charge of. And that's done within 56 days of the appointment. And it's important to also update or amend that inventory as additional information is identified. You're going to want to be thorough and complete in the identification of those assets to ensure that you're making sure that the court is fully aware of the assets that you're protecting. Now, this is really important because the court may require a surety bond in regard to the assets that you're managing. A surety bond is a guarantee of performance. A surety bond protects the person upon which you are serving as conservator. In the event that you misappropriate, steal, somehow or another the money is lost, if you're unable to return that money and make the conservatorship whole, the surety company would be held responsible and would guarantee the performance of your actions. So when you file the inventory, often the court is looking at the value of the liquid assets. These are assets that could be readily stolen or misappropriated, and then we'll set an appropriate bond. So it's really important that you accurately list that information. In addition, you'll see that there's a requirement to do an accounting at least annually with the court, and that occurs within 56 days of the anniversary date of the appointment, and that can also be set by the court. So it's important to calendar that date. Don't rely on the court giving you notice of the calendar date or the anniversary date, but rather calendar that date and make certain that you're proactively doing your accounting rather than waiting for the court to notify you, because often there are mistakes with the court's mail or email system, and you just don't get that notice, and the next thing you know, you've been suspended or removed as the conservator. In addition, it's really critical to keep accurate records, really meticulous records, during your time as the conservator. It allows you to have that information and account on an ongoing basis so that when you file your annual account, you have all that information already at your fingertips, rather than trying to remember what occurred and where are those receipts for events that occurred much earlier. In addition, if there's any change of addresses, you have 7 days of any of those changes for either yourself or the individual to notify the court. And if the person dies, you are required within 14 days to notify the court of the death, and then that may trigger the termination of the conservatorship and a final accounting. Now, the conservatorship will remain in effect generally year to year as you file your annual accounts until, of course, you are either removed or the conservatorship is no longer needed and it's terminated, or upon the death of that individual. The bottom section, again, just talks about some of the duties and reporting requirements of you as the conservator. At the Probate Pro, we're passionate about probate-related issues. If you have questions about conservatorship or any probate-related matter, give us a call, 833-PROBATE, or visit us at theprobatepro.com.